Hi, my name is David Haig, and on December 18th I was tased 10 times for trying to present evidence to prove my case. That evidence would also prove serious criminal conduct by government officials. Since I was prevented from presenting my evidence then, I'll try to do so here. One of the issues I was going to try to prove is that the Alaska Court of Appeals had falsified this memorandum opinion to justify not giving me an evidentiary hearing on my evidence. This is December 21st, 2016, and in it, the Alaska Court of Appeals claims, rules that on my claims of prosecutorial misconduct and statewide corruption. The court says Haig alleges that he's a victim of a wide-ranging conspiracy intended to frame him in order to protect the infant wolf control program from program-ending scandal. To this end, Haig claims that the state attorneys responsible for prosecuting his case, Haig's own attorneys, and the Alaska Commission on Judicial Conduct, the Bar Association, the Alaska Public Defender Agency, and virtually every judge involved in his case have all colluded together in a vast conspiracy against him. Haig's allegations are, for the most part, simply unsubstantiated general allegations of wrongdoing without any specificity or support in the record. We therefore agree with the district court's decision to dismiss these claims for failure to state a prima facie case for relief. As we explained in LeBrake versus State, courts are not required to simply assume the truth of pro forma assertions of the ultimate facts to be proved when these are not supported by specific details. The actual physical evidence I have against the Alaska Commission on Judicial Conduct, I already videoed in my number 2 evidence packet, which is on Facebook and YouTube. And what I'm going to do now is go over the briefing that was given to the Alaska Court of Appeals. On July 24, 2013, I filed this in the Alaska Court of Appeals. It's my opening brief. And so the Court of Appeals had this in their hand when making this decision that I did not give specific details. Alaska Commission on Judicial Conduct Proceedings. Haig complained the main witness against him, Trooper Brett Gibbons, chauffeured, ate with Judge Margaret Murphy, she was my trial judge, while she presided over Haig's trial. ACJC investigator Marla Greenstein, the only investigator of Alaska judges for the last 26 years, requested witnesses and Haig provided 4. Haig's wife Jackie also sent ACJC documentation she personally witnessed Murphy being chauffeured by eating with Gibbons full-time during Haig's trial. Greenstein is recorded stating complaint was dismissed after Murphy Gibbons testified no chauffeuring took place until after Murphy sentenced Haig, and that she, Greenstein, contacted all witnesses provided by Haig and none witnessed Gibbons chauffeuring Murphy. Disqualification of Murphy by Superior Court Judge Stephanie Joanides. Haig filed post-conviction relief application and state asked Judge Murphy to decide it, even though one of Haig's claims was Judge Murphy was corrupt. Over Haig's objection she couldn't decide a case against herself, Judge Murphy was assigned. Haig asked she disqualify herself. Murphy refused. And Judge Joanides was assigned to review the refusal. Haig approached the same witnesses he had given to Greenstein and all swore out affidavits that no one, other than Haig, had ever contacted them regarding the chauffeuring of Judge Murphy by Gibbons, and each personally witnessed the chauffeuring during Haig's trial and or before sentencing. Haig found the trial record recorded Murphy joking with Gibbons about his chauffeuring her before Haig was sentenced. Haig presented Judge Joanides A, recordings of Greenstein claiming she contacted Haig's witnesses and none of them seen the chauffeuring. B, documentation Murphy Gibbons denied chauffeuring before Haig was sentenced. C, affidavits from the witnesses that Greenstein had never contacted any of them and that each personally seen Gibbons chauffeuring Murphy before Haig was sentenced. And D, court record of Murphy and Gibbons joking about the chauffeuring before Haig was sentenced. Judge Joanides over Assistant Attorney General Andrew Peterson's objection, this, quote, may be a career ender for Judge Murphy, unquote, allowed Haig to subpoena Judge Murphy, Prosecutor Scott Leaders, Attorney Chuck Robinson, Magistrate Woodmansey, Attorney Brent Cole, Investigator Greenstein, and Attorney Dale DeLifka. Ordered Trooper Gibbons be produced and scheduled a 2-day evidentiary hearing for Haig to question all and the witnesses who Greenstein falsified contacting and whose testimony she falsified, to prove Murphy and Gibbons and Greenstein lied and conspired to cover up Gibbons' chauffeur, Judge Murphy, during Haig's trial and before sentencing. And Greenstein falsified contacting witnesses, falsified their testimony. All subpoenaed, other than Attorney DeLifka, tried quashing their subpoenas, with Judge Murphy and Magistrate Woodmansey hiring Peter Mawson, an Alaska Supreme Court justice, to do so. Judge Joanides ordered ACJC Greenstein to timely provide the investigative report into the chauffeuring, quote, in order to fully access the issues of impartiality and information provided to the Judicial Conduct Commission by Judge Murphy, Officer Gibbons, and any other witnesses in the Commission's investigation of Mr. Haig's complaint, unquote. ACJC Greenstein refused. In other words, they refused to provide Judge Joanides their investigative report. Judge Joanides disqualified Judge Murphy, ruling Haig had already produced enough evidence to justify disqualifying Judge Murphy without the 2-day evidentiary hearing. All subpoenaed witnesses, except Attorney DeLifka, were now trying to avoid. Judge Joanides stated she didn't resolve if chauffeuring occurred during the trial as well as sentencing, any of Haig's concerns about what occurred at the Judicial Conduct Commission, and that witness affidavits raising question over the extent of Murphy's contact with prosecution witness Gibbons during trial raise a sufficient appearance of impropriety that will negatively affect the confidence of the public and Haig himself in the impartiality of the judiciary. Judge Joanides stated Haig's claims, quote, would require an evidentiary hearing that is best held in the post-conviction relief proceeding itself, unquote. And remember, that's the exact evidentiary hearing now the Alaska Court of Appeals is denying me, saying I did not give any details or evidence that one was required. And here Judge Joanides has stated it was required. Judge Joanides gave Haig a hearing to prove he was not representing himself voluntarily, that corruption in Alaska's attorneys forced him to. Judge Joanides, my role was very limited in deciding whether Judge Murphy's decision not to recuse herself should be upheld, and I decided that on the appearance of impropriety grounds, without reaching on issues of specific wrongdoing, I agreed with you. There was an appearance of impropriety at a minimum. That's the transcript. Attorney DeLifka testified, it's absolute, unadulterated, self-bred corruption if they, the Court of Appeals, do right by you and reveal, you know, you have the attorneys going down, you have the magistrate, judges going down, you have the troopers going down. That's his testimony. Judge Joanides certified the evidence Murphy, Gibbons, and Greenstein conspired to falsify an official ACJC investigation to corruptly exonerate Murphy, and then referred this evidence to authorities for prosecution. Haig filed a bar complaint using Judge Joanides' certified evidence that Greenstein falsified an official ACJC investigation to corruptly exonerate Murphy. Greenstein, in a verified response, testified that in addition to contacting the witnesses Haig provided, she also contacted Attorney Robinson about the chauffeuring. Haig called Robinson and recorded him stating that until Haig's call, no one had ever contacted him about Murphy being chauffeured by Gibbons, and that he, Robinson, remembered Gibbons chauffeuring Murphy during Haig's prosecution. Haig provided this to the bar, and although this was evidence Greenstein had now committed perjury to cover up her false ACJC official investigation, Barr refused to investigate. Haig presented Department of Justice with proof Greenstein falsified official ACJC investigation of Murphy and then committed perjury to cover up. Section Chief Doug Klein stated Greenstein falsified her investigation because no one would believe it fair if the main witness against Haig were chauffeuring the judge presiding over his trial. DOJ asked Hague to continue providing DOJ evidence. After Judge Joannides' referral to ACJC that Greenstein, Murphy, Gibbons were corrupt, Hague inquired into it. ACJC Chairman Judge Ben Ash stated nothing would be done, as ACJC Greenstein didn't consider Judge Joannides' certified evidence as genuine. Witnesses whose testimony Greenstein ACJC falsified asked to testify at ACJC public meeting. Judge Eisch refused, even though ACJC rules encourage public testimony. And when witnesses showed up hoping to testify anyway, a trooper SWAT team met them at the door. ACJC could find no record of Jackie Hague's letter documenting she also witnessed Gibbons chauffeuring Murphy full-time during Hague's trial, even though ACJC Greenstein is recorded acknowledging receipt of Jackie's letter, meaning all witness testimony confirming the chauffeuring has been eliminated from ACJC records. Judge Joannides, when informed ACJC Greenstein claimed her 43-page referral was not genuine, referred 77 pages of certified evidence proving Murphy, Gibbons, Greenstein's corruption to all 9 ACJC members, to Greenstein, to Judge Murphy's attorney Mawson, who's a Supreme Court Justice, the Alaska Judicial Council, Alaska Bar Association, Judge Bauman, the Office of Special Prosecutions, and Ombudsman. To date, not a single entity has investigated Judge Joannides' referral. Greenstein ACJC are corrupt, including but not limited to A. Conspiring with Murphy Gibbons, B. Falsifying investigation of Gibbons chauffeuring Murphy during Hague's trial, by falsely claiming to contact the witnesses and by falsifying testimony witnesses would have given had they been contacted. C. Falsifying verified documents to cover up. D. Refusing Judge Joannides' request for prompt review of documentation into investigation. E. Claiming Judge Joannides' certified evidence of corruption was not genuine. F. Corruptly exonerating Judge Bauman of falsifying affidavits. And G. Calling in trooper SWAT team to prevent witnesses whose testimony Greenstein ACJC falsified from publicly testifying of this corruption. Why did all this happen? Without a doubt, justification was to frame Hague to protect infant wolf control program from program-ending scandal had been exposed. Hague was telling the state was telling permittees to shoot wolves anywhere but claimed they were taken for the program. So it seemed effective when animal rights activists were asking it to be shut down as ineffective. Now everyone is covering up the state, Hague's attorneys, and Murphy conspired to frame Hague. The cover-up is worse than the crime, Watergate, ending in President Nixon's resignation and imprisonment of 43 top officials. Operation Greylord, corruption so bad Illinois' judicial system was held hostage, and Department of Justice imprisoned 15 judges, 48 lawyers, 10 sheriffs, 8 police, 8 court staff, and 1 state legislator. Alaska's tally, Greenstein has been the only investigator of Alaskan judges for 26 years. So every judge she investigated is suspect. Greenstein gets 20 complaints a month times 26 years. This equals 6,240 possibly corrupt Alaskan judges. It's indescribably evil for investigator Greenstein continuing, apparently unopposed after her trooper SWAT team quashed testimony that would have exposed her, to falsify investigations to cover up for corrupt judges. Will this Court of Appeals grant relief? The reason why you've still not resolved your legal problems is corruption. If they, appeals court, do right by you and reveal, you know you have the attorneys going down, you have the magistrates going down, you have the troopers going down. This is Dale DeLifka's testimony. After this court first unjustly denied Hague relief, more people, entities have been implicated. If this court didn't do right the first time, it sure can't now. A growing number have pledged to hold accountable those responsible, no matter what. They claim they aren't doing this for Hague. They claim that until this evil is ended, they may be next. And until this is ended, our Constitution, for which so many have died and sworn to protect, isn't worth the paper it's written on. Your case has shades of Selma in the 60s, where judges, sheriffs, and even assigned lawyers were all in cahoots together. That's also from Dale DeLifka. All concerned agreed the following action must be taken at all costs. Exhaust state remedies as DOJ requires before prosecution. Document all delays as certain DOJ's requirements being used in conjunction with court delays to starve into submission those aggrieved. Ask everyone possible attend the as yet to be scheduled oral argument in front of this Court of Appeals as DOJ will be attending. Document how this court will twist facts and law to suit an increasingly tortured cover-up now embroiling itself and numerous others. And so what I'm claiming is the Court of Appeals is lying that I didn't give details. They twisted the facts. I also gave the Court of Appeals a reply brief that has just about as much documentation of the details of the corruption of the Alaska Commission on Judicial Conduct and Marla Greenstein. I'm only going to go through the first one in this to show people how much detail I gave the Court of Appeals. Haig alleged provided independent witness affidavits that A, while Murphy presided over Haig's trial she was chauffeured by and had meals with the main trial witness against Haig, Trooper Gibbons. B, Murphy, at Gibbons' request, eliminated Haig's evidence out of the trial. That was evidence that I was shooting the wolves exactly where the state told me to. But that evidence got removed out of the court record while the court record was in Judge Murphy's possession. C, Judge Murphy refused to do anything about Gibbons' trial perjury. D, knowing it was false, accepted and used Gibbons' perjury against Haig. E, Murphy made conflicting orders to harm Haig. F, Murphy refused to do anything about the violations of Haig's rights after they were pointed out to her. G, Murphy Gibbons falsified testimony to cover up their trial contacts. H, that if Murphy Gibbons falsified testimony to cover up their trial contacts, they must have conspired to harm Haig. I, Murphy Gibbons conspired with investigator Greenstein to cover up their trial contacts. J, Murphy Gibbons falsified affidavits to cover up their trial contacts. K, Greenstein falsified her investigation of contacts. And I, Greenstein committed perjury to cover up her corrupt investigation. Haig provided tape recordings certified by Judge Joanides as true, which proved the foregoing. No reasonable person can claim Haig didn't already prove appearance of impropriety or that Haig didn't make a prima facie requiring an evidentiary hearing case. Judge Joanides already ruled Haig has done both. A trial judge's involvement with witnesses establishes a personal disqualifying bias. Bracey, U.S. Supreme Court, 1997. A trial court must be ever mindful of the sensitive role it plays in a jury trial and avoid even the appearance of advocacy or partiality. U.S. v. Harris, 9th Circuit, 1974. Alaska Court of Judicial Conduct, Canon 2. A judge shall avoid impropriety and the appearance of impropriety. The test for appearance of impropriety is whether the conduct would create in reasonable minds a perception that the judge's ability to carry out judicial responsibilities with integrity, impartiality, and competence is impaired. The main witness against Haig chauffeuring dining with Judge Murphy while she presided over Haig's trial violated all of the above. Then Judge Murphy and Gibbons made it 1,000 times worse by lying to cover it up. Like I said, there's a bunch more here, but I don't want this video to be too long, so go back over there to Cassie. So is it true that I didn't give the Court of Appeals any details of the corruption of the Alaska Commission on Judicial Conduct or Marla Greenstein? Or is it true that I gave them overwhelming detail and the Court of Appeals is lying to justify not giving me an evidentiary hearing on this issue? And I want everyone to remember that the evidence I want to bring in could potentially expose thousands of corrupt Alaskan judges. Thank you.